I think it is clear to believe in the power of ideas.
Fresh thinking of the Manhattan Institute.
Good afternoon, everybody. My name is Chris Papagianis. I'm the Managing Director of E21, Economic Policies for the 21st Century. On behalf of E21 and our partner organization, the Manhattan Institute, I want to thank everybody for coming here today. I also want to thank all of our panelists for coming. Many of them had to travel in town. And also our moderator, Nicole. In typical fashion, a short intro here. I'm going to turn it over so we can get to the issue at hand. Nicole.
Thank you so much. Yeah, in typical short fashion as well, we'd like to dig into these issues. I just got off the train, actually, from anchoring a show on CNBC called Worldwide Exchange, and it is the only global show on CNBC. And the state issue is something that I've reported on since the middle of last year, and then this lady named Meredith Whitney made it very sexy, and so everybody started talking about it. But being the only global show on the network, we really find this to be one of the most important issues of our time. So with no further ado, I did travel across the country for a series called States of Pain. I found this guy, David Skeel, over Christmas and wrote a couple of op-eds about state bankruptcy. We know it's an issue. We want to know how to fix it, so let's get going. First of all, if everybody could just probably state where they stand on the issue of state bankruptcy. I'm not sure if everybody agrees with it, so perhaps we should just, I know you do, but everybody else.
So I am enthusiastically in favor, which makes me the target, I think, for many of the comments that will follow.
I don't think it's necessary, so I guess I'm against.
Okay.
I'm well positioned between David and EJ. I think under the right circumstances, it's just fine.
I am skeptically awaiting evidence that it is a practical solution to any state problem, short-term or long-term.
I'm similarly opposed to the idea. I think that it's far worse than some of the alternatives like conditional bailout.
I am not against the idea of state bankruptcies per se, but you would have to build a state bankruptcy system that created incentives to get people to the right result. The concern I have is that you could build a system that actually encouraged irresponsible behavior rather than one that got you to the right result.
Okay, so David, how would state bankruptcy work? We obviously know that there are going to be logistical nightmares, political nightmares, but how would you see it playing out?
Well, a key threshold issue that a lot of people have is whether it would be constitutional at all. And the biggest question people have is the issue of state sovereignty, which is protected by the 10th Amendment and the 11th Amendment and the structure of the Constitution. In my view, that is something that has to be worked with, but it is easily worked with. The key would be state bankruptcy would have to be voluntary. You couldn't provide a mechanism for states to be thrown into bankruptcy, consistent with their state sovereignty. And you also could not directly interfere with their state governmental decision-making power. So you couldn't have a bankruptcy court forcing states to raise taxes, for instance. If you do that, you can use something that looks a lot like the normal bankruptcy process, and the real beauty of it is rather than singling out one or two constituencies to bear most of the pain of a state's problems, bankruptcy brings everybody to the table.
Does it bring everybody to the table? Does it bring the bondholders to the table? What do you think? I mean, is that one of the reasons that you come out against it?
Well, I see it from a different perspective, I guess. On the legal issue, I should say right up front, I'm going to yield to the lawyers at the table. I don't pretend any knowledge of the issue of whether it really is constitutional or not or how it would be constructed, although I have many questions about that. My own background is something of 30-odd years in different capacities as both an observer of and a participant in budgeting at the state and local government level, familiarity with the politics that's involved in that. I've not only watched the sausage get made, I've actually helped make the sausage at times, and I have stains on my apron to prove it. So I'm going to yield on I'll do what you lawyers call stipulate. State it is constitutional to have a federal bankruptcy statute. The core of the argument that I hear in reading David's articles and some of the other articles on this, which were really provocative and compelling, and have started a worthwhile debate. But the core of the argument, if I have it correctly, is that it's desirable. It's not just possible, but it's desirable because, as you put it, we'll bring everyone to the table. Well, what's the point of bringing everyone to the table? And the core of that argument, as I understand it, is it will give states tools they now lack to tame and ultimately restructure, to tame their unruly debts and to restructure their finances. And that this is desirable because this will ward off any attempt by states to seek a federal bailout. And for reasons I'm sure we'll get into in the Q&A, I actually am unpersuaded on both those counts. And that's why I am opposed to the idea in the general sense that I'm opposed to doing anything in general that actually doesn't serve a useful purpose and could actually lead to unintended consequences. So, and I want to add, I don't have a visceral problem with response to the issue of the states being in trouble. I suspect we all agree to varying degrees with the argument that states are in serious trouble. States and municipalities are in much bigger trouble than they acknowledge. They've dug themselves into much deeper holes than they acknowledge. They have enormous unfunded pension liabilities and other liabilities that have brought some of the states to being fairly close to the brink of real insolvency. So that's where I start out from.
Well, absolutely. And, for one of my pieces, Dr. Doom projects that to be, $3 to $5 trillion in unfunded pension liabilities, 20% of GDP. The muni bond market is another 20% of GDP. If you made the sausage, though, I'm wondering, there are a lot of ways to cook this sausage. Right? You can fry it, you can bake it. I'm a vegetarian, so I don't actually know many ways to cook sausage, truth be told. But why not have that as an option? Use it, don't use it, have that as another tool in the quiver, so to speak. Yeah, sure.
Well, that leads me to some questions I would actually like to put to Professor Skeel and to some of the other lawyers in the panel, because I don't see what the option gives you, what authority it gives a state that it doesn't already have. For example, the argument is the states are laboring under a burden of debt, and principally by debt you mean the pension liabilities, because most state debts are not actually that unmanageable or heavy by historic standards.
Pretty big.
Some are pretty big. No, I mean there was a handful.
$60 billion of bonds in Illinois is.
Well, I mean the state of Illinois. There's a couple of. This is like the. I guess it's Tolstoy. I double-checked with you, Clay, beforehand. Every unhappy family is unhappy in its own way. We're talking about 50 states and about 30 really unhappy families out of them, and Illinois is unhappy in a different way than almost any place else.
But talk to me about what Illinois is doing. They have started implementing austerity measures on a tax level. I can't see you guys. Can I stand up, Tony? Is that possible? Or let me just see. Perhaps, let me just scoot over. That would be easier. And we can open this up. What Illinois is doing is implementing austerity on a tax level. So you have those unintended consequences on an economic level, as well as potentially companies, corporations that are headquartered there, the Caterpillars, the Deeres of the world, leaving to go somewhere else.
Well, and Illinois is doing what Illinois is beginning to do what Illinois can do. Whether it does enough is the open question. I would cite a contrast between Illinois and, say, Wisconsin. Wisconsin elected a governor backed up by a legislature whose way of confronting their liabilities associated with public employees is to go to the root of the problem, which is their law mandating collective bargaining for public employees, and talking about pulling it up root and branch and restructuring that in ways that allow them to get at the source of their problem. Now, Illinois is different. But I would note that today's Wall Street Journal has a story about the Speaker of the Illinois House, Michael Madigan, who is also the Democratic Party chairman in Illinois, whose handprints are on everything bad that's happened in Illinois probably in the last 20 or 30 years financially, who is now at odds with the unions and reportedly in league with those who want to look at restructuring pension benefits for active employees. which kind of points to the issue, to what I'm getting at, which is not to deny that there's serious problems, but to point out that that the sovereignty of states also means that they have the ability to restructure their own laws.
They can't do that with pensions. I mean, in Illinois, you cannot even restructure unearned benefits of current employees. You cannot touch the pensions.
But I guess the belief in it's not clear whether that's the case yet, but I'd like to hear.
It's pretty clear under state law.
David, or whomever wanted to jump in.
Go ahead, David.
So one question I have I think there are a number of legal problems, but one is how a state could opt into bankruptcy in ways that violate its own laws, and particularly its own constitutional rules. That I think the bigger problem, legal problems, are not federal constitutional, although I think there is a contract clause problem as opposed to a 10th Amendment problem, but rather at the state constitutional level. For states to opt in to bankruptcy, they can't do so in ways that violate their own constitutions. Their state courts, their state Supreme Courts, will tell them that they've violated their own constitutional rules. And so to the extent that these rules are rooted in state constitutions, state debt limits, state rules on how legislation gets passed, I think that the ability to opt in to bankruptcy, particularly to opt in quickly enough to make it a relevant proposition, raise really big state constitutional problems that I don't think are addressed, at least in the proposals as they're currently been discussed.
Are they addressed?
Well, I think that...
Can they be addressed?
Right.
Can they be amended?
Well,
Can
of
they
course,
be changed?
state constitutions are not like the federal
Living,
constitution by
breathing.
and large. There's a lot... I'm speaking quite generally. There's a lot of variety among state constitutions, but in general, state constitutions are far more susceptible to amendment than the federal constitution. That's not to say it would be easy. The same political groups, the same interest groups that have solidified and consolidated their benefits within current state constitutional language are going to be pretty well mobilized to avoid any amendment of that. So there are the practical political issues that affect, in fact, the legal issues. So I think David's got to be right. But constitutions are kind of interesting animals. They're more than just legislation in order to avoid majorities being overriding a minority at any particular point in time. But at the same time, constitutions, including state constitutions, typically have built within them their own anti-entrenchment mechanisms. So there's always emergencies. So when David speaks in terms of state debt limitations, there's a well-understood doctrine that those limitations can be overridden for debt emergencies, including often the payment of judgment bonds. So I think Dave is correct, David Schleicher, on a technical issue about being wary of state constitutional constraints, but I'm not sure that they're insurmountable.
Can I give a different answer? I mean,
Sure.
I'm just sort of going at that from a different way, which is we're talking about outside of bankruptcy. I am much I think the constitutional concerns, state constitutional concerns as relates to federal bankruptcy are much less serious than the other David suggests. The bankruptcy clause gives Congress sweeping powers to implement bankruptcy laws. The supremacy clause of the Constitution makes clear that those laws will trump an inconsistent state law, and I don't think that you're going to get decision saying a state using bankruptcy when bankruptcy is implemented under the bankruptcy clause is somehow impermissible.
I think in general you're right. I think it's going to be much more complicated when the bankruptcy clause comes up against the contracts clause, which I think is one of the concerns that David has.
But that's that's a completely different issue.
All I'm saying is that if the state has, as you suggested, a state constitutional prohibition on interference with pension obligations, for instance. And it's less clear to me that a bankruptcy clause power that allows the undoing of that contract in bankruptcy is free from contracts clause constraints under the federal Constitution.
And I think where that issue really comes into play is if Congress were to try to enact a law that, say, targeted just one type of contract. If Congress were to enact a law that said, we're going to let states abrogate their public employee collective bargaining agreements. That, I think, would be a contracts clause problem. The Congress would be simply enabling states to get out of their contracts. A full-blown bankruptcy procedure, I really don't think, is ultimately going to raise contracts clause problems.
What about a prepackaged bankruptcy?
Well,
like a GM style?
yeah, but the paradigm for a prepackaged bankruptcy, while certainly it might work in a state bankruptcy context, I'm not sure whether or not it's a necessity here, because what you're really talking about is negotiating a process where you're going to go and get approval. And frankly, I think that state bankruptcies are more going to be about allowing a process to take place and to give other parties the opportunity to think about what's going on. I think you can always negotiate. And I don't think that what's going to cause a state to file for bankruptcy is going to be the need to implement the prepackaged bankruptcy per se. I think that what's going to cause a state to file is some immediate liquidity crisis, and I just think that's going to play differently. I've wound up answering a question different than the thing I was going to speak about. So, if you
so many issues. I'm sorry.
No, it's all right. What I wanted to talk about is this business about whether or not a state filing for bankruptcy might violate its own constitution. And what I find interesting about that is the analog in corporate bankruptcy. Because in the corporate bankruptcy area, this comes up when the question is whether or not the corporation has authority under its own bylaws to file for bankruptcy. And there is litigation that is based upon that. That litigation, though, is not really bankruptcy law-based litigation. That is based upon the state of incorporation and whether or not under that state of incorporation the authority to take that action is appropriate. So it seems to me the question you would have to ask is whether or not the act of determining that you want to go into bankruptcy is an action that is authorized under your state constitution or not. I don't know the answer to that question, first of all, because I don't know what the 50 state constitutions say. But more importantly, I would think that, as this David said, that if a court were to find that the reason behind filing would be to abrogate the contracts clause, for example, they might very well find that a state doesn't have the authority to do that.
Well, isn't that also the problem that you're talking about 50 state constitutions
Yes.
and they're all different and all of the accounting is
that's
not uniform?
That's implicit in this whole discussion, which is that we are dealing with 50 states that have 50 different sets of rules and 50 different sets of problems. Now, of course, in corporate bankruptcy, there are thousands of corporations that have their own problems as well, and we do have a system that allows for that. But states are sovereign states, and there are different and special issues that come up in that context. And I do worry in creating a state bankruptcy system, can you create a system that allows states to get in, take care of their problems, and create the right kind of incentives for them to resolve their problems? I mean, we can talk about some of that later, but
I worry about just the idea of moral hazard. I worry about systemic risk. I worry about the risk of contagion as well. So stepping aside from the logistics for a moment, and we can get back to that. I mean, Nicole has been a little bit quiet, so I wanted to bring her into the conversation. You know, what are the potential risks of having one state file for bankruptcy and having the other ones go with them?
Having the other ones
potentially go with them.
Yes, I think that's a good point, Nicole. The issue of moral hazard is partly what is driving this politically, that many members of Congress understandably don't want to be caught in a position where they're having to bail out states overnight or presiding over a financial and fiscal crisis. And so they see state bankruptcy as an alternative to bailouts. And you see this in Newt Gingrich's article that he wrote with former Florida Governor Jeb Bush in the LA Times a few weeks ago, that we're not going to bail out states. Instead, we will tell them, go bankrupt, declare bankruptcy. The problem with that, as I see it, and I'd love to get some other reactions to this as well, state bankruptcy would be enormously complicated practically. We've heard some of the reasons why. One of the reasons is that states don't issue debt through one place, a state. They issue debt through, in some cases, hundreds, even thousands of special purpose corporations, public authorities, tax-secured debt structures. All of them give bondholders different degrees of protection. In some places, the pension obligations are not at the state level. Actually, that's the case in most places. So there is no way to figure out in advance how all of this would work in a bankruptcy. When you have had complex bankruptcies, to give a few recent examples, Enron, complicated, Lehman Brothers, complicated, those are liquidation bankruptcies. So some of the complexities are just dealt with by the fact that the companies are liquidating. You don't have to worry about staying open for business and going bankrupt at the same time. State can't liquidate. Complicated bankruptcies that aren't in liquidation have been Chrysler and GM, where the only thing that avoided liquidation was a federal bailout. And so there's no precedent, unless I'm missing something, that shows you that a bankruptcy statute avoids federal...
Try WorldCom. WorldCom was a complicated restructuring, lots of over 1,000 different entities, went pretty smoothly.
And why would you say that precedent would be stronger than GM, Chrysler, particularly with the political implications involved of a state going bankrupt?
The government couldn't play the same role with a state as they did with GM and Chrysler. The government couldn't come in, be the lender, and insist that a state do X, Y, and Z. So I think they're very...
Exactly the problem.
Can I get into
course.
the moral hazard? So I'm got a different view of the federalism issue than David Skeel does. I think part of the problem here is that the federal government cannot credibly commit not to bail out states. There's just no mechanism for doing it. And indeed, they probably shouldn't do it. If we thought that Citicorp was too big to fail, it's difficult to think that California isn't too big to fail. And the problem is not necessarily systemic risk in the sense that if California goes, other states will go. The problem is that there is contagion risk with respect to things like interest rates. So that if California goes, my guess would be there would be some fiscal pollution, and other states and the federal government will end up paying significantly higher interest rates. The consequence of that is that there may actually be a significant federal interest sufficient to overcome some of David's federalism problems in both generating a state bankruptcy statute and in allowing courts to have significant authority in bankruptcy proceedings. Now, I want to suggest that might not be a terrible idea, and here's the reason I suggest that. Creating a state bankruptcy statute as an option to a potential bailout creates a nice strategic game. One could imagine that in order to avoid the contagion risk or the fiscal pollution risks, the federal government, under some circumstances, might actually prefer bailout to bankruptcy. That would avoid the contagion. But they would prefer, the federal government presumably would prefer it if, but only if, they could place some constraints on the state officials as a condition of, and I take it this is what David was referring to when he talked about conditional bailouts, as a condition of getting the bailout. And as long as that's consensual, there's no constitutional problem. The game, however, starts if the state has a bankruptcy option and can say to the federal government, well, thanks very much for your bailout offer with high restrictive conditions, but we would prefer bankruptcy, which creates contagion effects. Unless you're willing to reduce the conditions for the bailout, then we'll take that. So the bankruptcy option poses or creates a credible threat for state officials actually to extract concessions on the bailout front from the federal government. So when I say what I favor is the possibility of a well-structured bankruptcy proceeding, that entails allowing more authority over what happens in the bankruptcy than David is willing to allow under what he sees as federalism principles.
But David, just to clarify, you're not advocating that the states actually go through with the bankruptcy, as Nicole was alluding to, the expensive process. You're advocating this as a bite to the bark that we're hearing from governors,
Right. Well, just to go back to a term that EJ used, EJ suggested that some proponents think that bankruptcy is desirable. We want lots and lots of states to be filing for bankruptcy. That's not my position at all. I hope nobody files for bankruptcy. What is desirable is that we have a last resort option in place if everything else fails, that we have a bankruptcy statute. So I'll say that. I'll say one more thing to Clay's argument. I really think the systemic contagion risk issues are much, much less serious than Clay and a lot of people believe. That's the idea that there's this huge contagion problem is based on a presumption that the bond markets can't distinguish between California and Texas, that they think that if California is at great risk of defaulting, so is every other state. But the bond markets are really good at distinguishing between the good risks and the bad risks. That's why California has to pay so much money to borrow money right now.
I kind of wonder, I've got a couple questions for David. One first is what he makes of the example of the New York City bankruptcy of the 1970s. So the federal government eventually did step in after a state reorganization, and it did so because it saw these exact contagion risks we're talking about. That after Ford said to New York, drop dead, he said, you don't have to drop dead. I'll give you something, but I'm going to make it hurt a lot. I'm going to give you some really painful medicine. And it did, so that's, I guess, would be my first question, which is, do you think that Ford didn't have to do that? And if so, why not?
So, so tell me more about exactly what you see Ford is doing. I mean, this was not a clean bailout of New York City. And I mean, most of what was
helped
done
fund the MAC bonds.
It was mostly done by New York State, what was done with New York City.
They funded...
Actually, Ford didn't. The federal government simply free rode on the constraints placed by the state, and I think it was exactly the game that I'm concerned about. Because New York City had the bankruptcy option, the federal government, because they were concerned about contagion risks, couldn't impose as many restrictions as they might have wanted to. Plus, it's difficult for the federal government to monitor a city. They had the state as the intermediary. That would not be true in this case. But David, I think you got to look at the empirical evidence on contagion. So, and we don't have any empirical evidence from states, so unless we go back to 1840s. And remember, in the 1840s, there was an attempt to have the federal government bail out, assume the debts of heavily indebted states, and it didn't go through. Congress simply said, tough, you're on your own. Were there contagion effects? Not sure, but the one thing I'm pretty sure of is that the bond market and the United States economy of the 1840s is not the same as it is in 2011, so I'm not sure we can extrapolate too much from that. However, what we can extrapolate from, David, is what happens in the municipal market. So if you look at the econometric studies of what happens after the Orange County bankruptcy, and remember, Orange County paid back 100 cents on the dollar, but the studies of what happened in Orange County is that other units in California paid significantly higher interest rates as a result of the Orange County bankruptcy. The Orange County bankruptcy was a one-off item related to investments in derivatives by the treasurer of Orange County. It had no real spillover effects for anybody else, and yet there was measurable contagion. So I'm not sure why you think that wouldn't exist at the state level.
Well, the effects after Orange County were quite short-term effects. And then the other recent example that I think in some respects is even more relevant is Argentina. When Argentina has serially defaulted, there is invariably a difficulty going to the market for more funds for Argentina right after the default, but the market recovers really quickly. And so the possibility of there being a short-term effect, I think, is worth living with.
But haven't we already priced this into the market? I mean, we're already talking about it, and this is progress for the most part. PIMCO has not backed away from snatching up their muni bonds by any means, and they're also betting on a federal bailout for the most part. So markets, can't they handle this if they know it's coming?
You know, the one thing I would say is that depending on which system you build, one of the things about those systems is who bears the actual loss. And let's talk about the three parties who actually conceivably bear the loss of these failures. Either the federal government would bear it, and which is what this implicit guarantee and all of with respect to government debt has, and that's what people are trying to avoid to have us pay for other people's problems. It's the local taxpayers, which is the other alternative. You know, you raise taxes and people can argue about the efficacy of that, raising taxes or cutting services. And the third alternative is that it's borne by the creditors. In the bankruptcy system that we're talking about now, which is largely, I think, based on Chapter 9 with respect to municipal bankruptcies, at the end of the day, the bulk of that cost winds up being borne by the creditors. The creditors take less money. And under a Chapter 9 process, the judge is specifically prohibited from ordering that taxes be raised or services be cut. That's very clear, and it's in there to deal with federalism problems, with sovereign immunity types of problems. So if you build a system that says that when a state goes into bankruptcy, it's just a mechanism to make sure that there's a clean process for which the creditors take less, that means when you go to the markets, assuming you have a rational marketplace, they're going to build that into the process as well. And the interest rate benefit that municipalities and states get because somehow there's this implicit guarantee that they'll never default, that the federal government will ultimately bail them out, disappears at the end of the day. If you go through a process over a period of time where it's clear that when a municipality or a state doesn't pay its bonds when it's in financial distress and it doesn't raise its taxes and it doesn't cut its services, I would suggest you may very well wind up with more expense to governments in borrowing money than less expense. So I very much worry when you build this system that you have to create incentives to make sure that governments put their house in order as part of the process.
So what would the alternative be?
Well, one alternative is, in Chapter 11, for example, one of the things a judge has to find is that when you get out of bankruptcy, when you confirm a plan, you have to find that the company is not subject and likely to be subject to further reorganization. In other words, the judge has to make a finding that you've actually fixed your problem. There is no such criteria in Chapter 9, and I suspect there would be none in Chapter 8, I think someone suggested.
Yeah.
Well, that means that the politicians who have put this entity into bankruptcy don't have to explain to anybody that they fixed the problem. They don't actually have to go into court and say, well, this isn't going to happen again. All they have to do is say, well, we got everybody to reach agreement. We kept them in bankruptcy for so long, they decided they might as well take our deal, and we've gotten out.
But how else can you reach an agreement? They're not coming to an agreement right now.
So I actually think that the answer is some type of conditional bailout in this respect. That rather than looking to the bankruptcy code, look to the other world of sovereign states, and we look at something like an IMF type situation as opposed to a bankruptcy type situation. That the problem I see with bankruptcy at a practical level is that it treats state indebtedness like it's a binge as opposed to an addiction. And bankruptcy is kind of like a drunk tank, a place where states could sleep off the consequences of their drunkenness, but not rehab. And that what conditional bailout does is it gives the bailer out the ability to put certain conditions, and which in return the state would get something: reduced borrowing costs, the benefit of not being the guy who's in charge when the state went bankrupt. But it would allow them to change the things that actually cause indebtedness, like insufficient revenue raising, excessive spending, and a kind of broken politics of budgeting, like you see in California. I kind of wonder how the proponents of bankruptcy, and I guess we have one and maybe 1.5, think of why states got into bankruptcy, need bankruptcy in the first place. Was it a one-time thing, a binge, or was it an addiction? And does that matter to whether you think bankruptcy is a good idea or a bad idea?
Can I add a question to his question? To kind of compound the question?
That gets it up to 3.
Okay.
Well, the question is, I understand that you're offering bankruptcy as something that should be plausible and that it will be something that will be behind glass to be broken in case of emergency, and its mere existence, the theory is, will be a lever that can be used to force concessions by creditors, principally unions and other and people benefiting from unaffordable compensation trends and pensions. The threshold question for me also is, there's been talk about they here. Who is the authority that can credibly wield the bankruptcy threat? That's a very important question. Under the sort of restrictive view you have of, I think, if I interpret it correctly, of bankruptcy as being sort of Chapter 9-like, Are you suggesting that a governor unilaterally could declare bankruptcy?
Okay, so I take that to be the third question.
Yes.
The first question was conditional bailouts. I mean, my answer to that is, where exactly is this money going to come from? I mean, one of the beauties about bankruptcy is, unlike almost everything else that takes place in this town, bankruptcy wouldn't cost more money, whereas a conditional bailout is just the opposite of that. With the IMF in the international sovereign debt crises, big problem was the IMF ran out of money, and it did not have enough money it would not have had enough money for the next bailout in the 2002. Why did states get into this predicament? I think it's a mixture of sort of drunken spending and not just that, but also I think some systematically bad incentives. One of the bad incentives with pensions is that if you are representing a union in a state with respect to pensions, you want to make that cost look as small as possible so that you can get as big a salary as possible. You've got one package, salary plus pension. You want to say, the state's not really giving us much of anything on the pension side, so you can make your salary as big as possible. State lawmakers have an incentive to agree to that. It's not a cost that comes due immediately, so there are systematically distorted incentives in the setting of salaries and pensions for state employees. In my view, at least on the margin, bankruptcy would create a countervailing incentive. It would force the parties to think about the possibility that if we promise too much, some of that might come back down the road because it could be restructured under a federal bankruptcy law.
But David, two things. First of all, why would they care about it if it's down the road? You just said these are the same elected officials who have short time horizons and decide to grant these things. Union, same thing. The current union leaders are worried about their current membership, not 20 years out. Secondly, you've just told us that you want all the decisions in bankruptcy to be made by political officials. You don't want federal bankruptcy judges having any inroads on the political or economic authority of the state. I would have thought that the disconnect in the incentives, with which I completely agree, would lead you to say that it's going to be difficult to restructure those incentives, so we need someone to be watching who doesn't suffer those same incentives. And while I certainly don't hold any torch for the incentive structure for federal bankruptcy judges, certainly they have a very different set of incentives that might be a corrective to what you're concerned about. So I'm not sure why, given your concerns, you're not with me on allocating more authority in bankruptcy to third parties, that is, bankruptcy judges.
Well, we've got that in the bankruptcy framework as we have it, not unilateral.
Not if we're talking about this a version of Section 904 in Chapter 9 being in the state
But what
system.
we have, and this is picking up on what Glenn was saying earlier, what we have in Chapter 9 for municipalities, what we have in Chapter 11 is the bankruptcy judge has to approve the proposed plan. It has to make a decision that this plan is in the best interest of the creditors. That is an indirect tool that the bankruptcy judge can use to force concessions. The bankruptcy judge can't say, you've got to cut this much out of your pensions or you've got to raise taxes. But the bankruptcy judge does have the power to say, you haven't gotten your fiscal house in order. I'm simply not going to approve this plan. So we've got that already in the bankruptcy process as we know it.
Well, and who makes the decision?
Yeah, I could ask the final question, and by writing them down, I did remember it. I think there's a fair amount of flexibility on that. That does raise state sovereignty issues. Does Congress have the power to allow, say, the government to unilaterally trigger the bankruptcy law? I think there's a debate one could have about that. My own inclination would be for the filing of the bankruptcy petition to require the legislature either to pre-approve by saying we're going to let the governor approve or decide when the governor decides, so that you have the legislature and the government deciding. With respect to the proposed plan itself, when we negotiate, decide what we're going to do to restructure the state's financing, I would propose a more streamlined approach, something along the lines of the governor's office has the power.
But let me tell you something, David. I have talked to every governor I've spoken to hates this idea vehemently, as you can imagine. The idea of the word bankruptcy gives them hives. So can we change the name? I mean, honestly, is that a stupid question?
You can call it whatever you want, and there are not just bankruptcies, and I can tell you that when a company files for bankruptcy, it's always we're going to get a court order to implement a restructuring. You never will see the word bankruptcy in there. You can use whatever euphemism you want for it, but if it's going to go through a political process where someone's got to put their name on it, there will be someone opposed to it who will call it bankruptcy, and I think the politicians have to worry about those consequences. I think the only way you ultimately, and this is harkening back to something you asked me earlier, as I've thought about it, the only thing that you could get like a state legislature and a governor to agree, I think, to file a bankruptcy would be to implement a pre-PAC, which is what you were talking about a little bit earlier, where you go through it. I mean, one of the things you get out of bankruptcy is you get binding of recalcitrant minorities. If you can get more than 50% number and more than 2/3 of the amount of a creditor class to agree, everybody else has to go along for it. So if you were negotiating with your unions and your bondholders and you had some holdouts, but you had the requisite majorities, perhaps you could go to the state legislature, the governor could go to the state legislature and say, we have a deal, but we have to run it through bankruptcy, and this is what we would have to do. And maybe that would work, but I worry that the entry point for a state bankruptcy will create political problems so as to make it virtually impossible that anybody would ever take advantage of it.
Yeah, but I worry with Bernanke coming out and saying we're not going to bail the states out. I worry about that. I mean, who has $1 trillion?
Well, I mean, practically speaking, bankruptcy will not repeal politics. That's why WorldCom is like completely irrelevant. WorldCom didn't have employees represented by the UAW. That's why nobody in Congress cared about it. That you're talking about hundreds of thousands. If you're talking about the pensions in particular, you're talking in a typical state about hundreds of thousands of sort of angry, scared union members who are the most politically active class of people in each of these states. And you're assuming that they're going to be kind of nowhere while the political class, which has the power to completely change all the rules by which they operate, including over a period of no more than, say, 3 years, amending the Constitution, that political class is going to throw up its hands and declare bankruptcy and then seem to jeopardize those pensions.
Then how do you look beyond those 3 years? How do you stop kicking this can down the road?
Well, I mean, I think that what has to happen is you need to actually see yourself in the way that Illinois does, paying 13% of its current general fund in pension contributions and still being behind and realizing that they're going to run out of money. And then you actually see the House Speaker turning his back on longtime allies or seeming to threaten to, and be willing to change the nature of the game. Now, it's not going to be a perfect solution, but what I'm saying is it's difficult for me to picture if we get over all these other legal obstacles, and I think the obstacle of entry into bankruptcy is overwhelming. I just don't see why, as I put it in my article.
Well, then why are you worried about that? If
I'm not worried about it. I'm not worried about it. This is where I come from.
You keep saying just how worried you are about it. I mean, you're arguing in both directions.
I'm worried. No, here's where I come from. It's a classic small c conservative viewpoint. If it's not necessary, don't do it. And if it might have consequences that actually are negative, don't do it. I can foresee circumstances. In some cases, it's quite possible that the unions will see it in their interest.
So what would you do?
Bankruptcy.
The states are too big to fail.
Bankruptcy? Nothing.
No, but what would you do to fix the states? I mean, the numbers we know: $25 billion in California, $15 billion in Illinois.
In other words, why do I have?
Alternative?
Who am I when you're asking me what would I do to fix the states? Congress? I mean, because the question is, what would I do to fix?
To the marketplace
No. Here's the question. The answer. If you're asking me, what would I do to fix New York? I've got a whole array of things for you, okay? If I'm Illinois, I've got a whole different array of things for you.
And that's part of the problem.
And the question is, at what point do those of us in this room have to care about what's necessary to fix Illinois, number one? Number two, and this is the core of Professor Skeel's argument that I really couldn't get my head around, was this will give them tools they need to actually fix their problems short of bankruptcy. I heard that argument. And thus nobody will come looking for a bailout. If a state...
I'm not saying I'm saying on the margins it has these effects. And just to go back to the whole bailout point, I agree completely with Clay. I don't think that you can eliminate bailouts.
Okay.
There's no way the government can pre-commit not to give bailouts. What I think we want to do is make the necessity of the bailouts as little as possible and as unlikely as possible.
That's a different argument than I've heard, because the strongest, I saw it sort of unequivocally stated, I thought, in some of the arguments for this, that we do this and we won't have to worry about them coming to us for bailouts. And that is just, I find that difficult to believe.
Put the words less likely that they'll come.
Well, let's look at New York City. One more thing. The one case, New York City, which is then as now is bigger than most states, fiscally, demographically, economically, in the mid-'70s, did essentially approach the point of bankruptcy. It could not roll over excessive short-term debt. It was basically on one Friday afternoon about to completely run out of cash without any recourse. It was basically in a classic sort of bankruptcy, near bankruptcy situation. And in the way that Professor Skeel is suggesting, they were, at a certain point, the politicians sort of in loco parentis there, particularly the governor, you carry, were able to wield the possibility of bankruptcy as a tool, as a threat. As to say to the unions in particular, look, we've researched this. If the city goes into Chapter 9, your contracts might be abrogated. What that yielded, but three things happened. The unions very reluctantly made some temporary concessions. There was no permanent restructuring of the way New York City runs. The permanent change was in their financial planning, which got much better and more transparent and is a national model now, period. What the unions made concessions in terms of wage increase deferrals. They allowed their pension fund trustees to vote in favor of buying city bailout bonds. The state did bail out the city, and the state in this situation was in the position that the federal government would be in a state bankruptcy, I would suggest. And in the end, the feds bailed out the city to an extent also. That's what happened. And they were able to, in other words...
So it was an option, one of many.
It's not less likely to need a bailout. It's unlikely that somebody still won't seek a bailout if they get into a situation dire enough to have someone credibly threaten bankruptcy. And again, I see the unintended consequences. I do believe in the contagion risk. I leave it to others here to argue that. And I believe that I can see situations where unions might actually find it in their interests to say, you know what, let's actually seek bankruptcy. Because they'd like to drag the bondholders into it. Even if it's a state like California that does not have really exceptionally heavy debt or a bad sort of, is not looking at it like miles of rough road on repaying its debt. But they want somebody else they don't want to be the last one standing.
I mean, when you talk about this, and now I'm talking about what David Skeel said, I think if this process actually works properly, you can mitigate federal bailouts, because what's happened is if you create a process, going back to what I was saying before, where the judge actually takes seriously the question about whether or not the state has actually put its fiscal house in order and ultimately says no, at that point, the question is what's next.
The question is also what is their fiscal house? We don't know the book value of B of A. We don't know the book value of Illinois. Does anybody know?
Well, but that's the point. When you go through a process like this, it's not perfect, but somebody's actually going to have to explain to the judge what the book value of Illinois is. Because the people who are getting repaid, the people who are having their debts restructured are going to be entitled to know that. And believe me...
Isn't that the problem with the banks, though? It's a 30-year problem. Nicole, come into this conversation.
When we speak of these liabilities and presumably the assets or the ability to pay future liabilities, who are these creditors who would be at the table? Because the pension creditors, for the most part, they work for local governments, the workers and retirees. These are obligations of localities. The localities simply send their pension contribution to the state pension fund to administer it. The state doesn't guarantee local pension funds. And the other set of creditors would be bondholders. Do you see, David, bondholders as having a role years or decades before bankruptcy in heading off of bankruptcy and saying, gee, we don't want to lend money to this state? Is that something you see?
I think on the margins, the possibility, you're going to factor in the possibility of a future bankruptcy, but ironically, bankruptcy would add more certainty, in my view, to the process rather than less, because the alternative now is, if there's a problem, do we have a flat-out default on the bonds? So I think you would factor bankruptcy into the process, but what you're factoring in is a much more orderly process in the last event scenario rather than an ad hoc one.
So
they're pricing in that premium for the most part. Good, David.
So can I ask a question, which is, why would a governor find bankruptcy better than default? In default, they can pick the creditors they pay. In bankruptcy, they can't. Why wouldn't a governor prefer to pay off the politically powerful or whatever, if the pensioners are politically powerful or the bondholders? Why wouldn't they want that power rather than to give that power to some judge?
Well, I think they may want the ability to deal with the entire picture. I mean, nobody's going to jump into bankruptcy. You're only going to file for bankruptcy if all else fails. I mean, bankruptcy is the equivalent of the fire department that you bring in if the fire rages out of control. So I don't think anybody ever wants to file for bankruptcy. I take those governors at their word when they say they don't like the idea of bankruptcy. But with a state that has the kinds of problems that Illinois has, arguably California has, it's not out of the question.
But so why again? I mean, you didn't quite answer my question, which is if they have two choices, bankruptcy or default, and default wouldn't go away just because there was a bankruptcy code. They still have sovereignly immunity.
If you default on your bonds, you're not getting rid of those obligations. Those obligations are still there. So as soon as you start paying anything, for instance, in a state like Illinois, where the bond obligations, general revenue bond obligations, are first priority obligation, as soon as you start paying anything, you're going to have to go back to paying those bonds. The simply default option, it works to a certain extent because a state is sovereign, but the mess doesn't go away. You just are sort of keeping that problem out there.
But why not something like the Paris and London clubs where they kind of work these things out? I mean, I'm just trying to figure out what the world would look like if in a last period situation without bankruptcy. And I wonder whether, faced with just not being paid for a number of years, which would be what would happen in a case of a default, they would stay there, but they also wouldn't get paid, and they would be suffering for that. They wouldn't do some kind of workout like we see in the Paris and London clubs.
Well, probably not everybody is familiar with the Paris and London clubs, but those are the group of main sovereign creditors, the creditors, sovereign creditors, the countries who have lent to, say, Argentina or Brazil or Peru. Paris Club is great. You can restructure your obligations, but the restructuring is very, very limited, or has been historically. It's involved changes with interest rates, sometimes a deferment of debt, almost never a restructuring of principal. Paris Club doesn't work with a nation that is in deep trouble. With someone like Argentina, the Paris Club solution isn't enough. And so what we're saying is, do we need a more thoroughgoing option in addition to these other kinds of alternatives? I'm all in favor of these.
Okay, so what are the other alternatives?
The alternatives are doing things like restructuring your collective bargaining agreement outside of bankruptcy, like trying to deal with your pensions if your state law allows it, things like that. And
that's like Missouri and Indiana. They can.
Right, yeah, some states you
have
a lot of flexibility to restructure.
Are there other alternatives, down the road? Clay?
Well, we've been talking a lot about the ex post and what happens once it hits the fan. To what extent can the state take care of its own problems? To what extent should the federal government be invited in to either engage in bailout or create a bankruptcy proceeding? So if we're willing to entertain that possibility of federal intervention ex post, then I wonder whether, David's conception of federalism notwithstanding, we'd be willing to entertain the possibility of some ex ante approach. If we were talking about the relationships between states and their political subdivisions, and by the way, on your what else to call it, the actual Chapter 9 title is Municipal Debt Adjustment, not Municipal Bankruptcy, because bankruptcy would be bad. So we could call it something else, and then the whole problem would go away.
Let's all think on it.
But if we were willing to entertain the possibility of federal intervention ex post, then the analog in the state municipal context is a significant number of states, by no means all, allow for the appointment of emergency financial managers or emergency financial boards when certain objective triggers are hit. Now, by objective, I don't mean, gee, those are the right ones. I just mean that they remove a little bit of the politics. So I sort of wonder whether, even with our conceptions of federalism, we might think that rather than have the federal government come in to try to solve the problem or worry about state politics getting in the way of a solution to the problem, whether, in order to overcome some of those mismatches of incentives that David was talking about, some sort of creation of a federal emergency financial manager or emergency financial board to call it advise the state, impose on the state. We can play the game here, but I do wonder whether.
But that's putting a Band-Aid on the situation.
Oh, no, I'm hoping not. I'm hoping that, in fact, it introduces an actor into the situation who does not suffer from the political disabilities that we've been talking about. In the same way that when emergency financial boards or emergency financial managers get appointed at the state level, it's not a Band-Aid. They take over functions of the municipality.
But isn't there a systematic issue as well? I mean, Nicole, we touched on this a little bit ago, the gap accounting. I mean, who knows? Is Meredith right? We can't figure it out. Nobody really knows what the value is. Nobody knows what the outstanding obligations are. And across the board, they're all different.
Right. That's really the key here, that they are all different. And so
putting a board or a SAR or a SARINA or whatever you want to do, that
exactly.
doesn't
When David says that this would add predictability and consistency for creditors, even if California had a terrific bankruptcy and it took them 7 years and they somehow got all of these liabilities, except the local pension liabilities apparently, into one place and worked this out, it wouldn't give guidance to any other state, because California's constitution, referendum process, state laws, each individual state lawmaker, governor, all different than all of those people and all those laws and processes in New Jersey, in New York, in Illinois. So this is a law that would only be used on a case-by-case basis. Laws should add consistency and predictability, not be a veneer over a process that is always going to be political in different in every single case. So this goes back to EJ's point that you can't repeal politics, and it's not only when you get to the point of bankruptcy, it's long before. That if you're a pensioner, you're going to have confidence that even if a state is allowed to go bankruptcy under the federal body of law, that the state will uphold its constitutional guarantee, if there is one, at the state constitution, to pay your pension benefits. If you are a bondholder, senior bondholder or tax secured or GO bondholder, you're going to have confidence that even if state has big problems, you are first or second in line to be paid before the state provides all of its public services. So not only are we asking creditors to believe in bankruptcy, but we're also asking them to believe that in a crisis, states will throw away all of their own processes and order of payment that they have set out and so forth, which I don't see as a good thing. We can't ask bondholders to solve democratic, political, and social questions.
But in bankruptcy as a general matter, it's not as if when creditors negotiate for specific rights, they go away. I mean, if you're a secured creditor outside of bankruptcy, you're a secured creditor inside of bankruptcy. In Chapter 9, they respect these special revenue bonds where you have allocations that are paid over in certain specific ways. The benefit, if you
But don't you sign up for that risk as well? I just looked up on the train, where the 10-year in California is yielding, it's 4.7%. You're the Treasury man. Where is the 10-year yielding U.S. stat? I mean, it's 3.7 right now. So aren't you? You're pricing in this premium. It's a risk. Something can happen.
You are pricing in risk. I think what we're all talking about is nobody actually knows what the risk is. This hasn't happened. The last time a state defaulted on its payments was Arkansas in the 1930s. I mean, this has been a long time. People don't know how this process is going to play out, and they don't know what the real risks are. And part of the reason why they don't know what the real risks are is nobody knows whether or not the federal government is actually going to stand behind this stuff. This is like what's going on with Fannie and Freddie right now. Nobody knows what the federal government's going to do to step up to the plate on these things. So while the market has some guess as to what the additional risk is, it's an imperfect guess. And that, that makes pricing this stuff very difficult.
And when bondholders sign up for risk, they sign up for different individual risks. Some California bonds, for example, they are not general obligation, full faith and credit bonds. The state simply says, we agree to appropriate this money. In some cases, it just says the governor agrees to ask the legislature for an appropriation. So this goes back to our federalism issues. If bondholders are taking comfort in taking a risk that the state won't appropriate this, that the legislature won't agree, how can the federal government add a different kind of risk onto that, put it in some kind of order that is not in the political order of the state?
David, any thought? I'm sorry, go
Sure.
ahead. EJ, was going to jump in?
For, just to make it even simpler, if the state says we agree to appropriate this, even if this is a fairly low creditor, if that's what it says in the covenant that the state has agreed to appropriate it when necessary, how can a judge say we're not going to respect this? They have agreed that they will appropriate it. That's their decision to do it or not.
This is because a general promise to appropriate is not a property interest. If you set aside money for a particular bond, you have a property interest in that money, and you will be fully protected. I mean, there are promises, and there are promises. Some promises are absolutely have to be honored, and those are the promises where you back that promise with actual assets or actual funds. When you don't, it effectively is a conditional promise. California has to put its full faith and credit behind its bonds unless it doesn't.
But that's the point. It's California's decision. It's the state's right to appropriate or not to uphold full.
And they have that right in bankruptcy too. They can say, we're not going to enter into a deal unless we pay all bondholders in full. I think that would be foolish, but
I think the market prices these risks all the time. Though there's a bond issue in Menasha, Wisconsin now that's going into default. It was a subject to appropriation bond, and the bondholders are saying no, those you have to pay them, and saying no, the contract says subject to appropriation, and we didn't appropriate. So I think that we are talking. I've assumed that when we're talking about bankruptcy, we're talking about GOs, we're talking about general obligations, and basically that's it. So, but those less than GO bonds are assessed by the market. Their risk is assessed by the market every single day. So I've got.
And we haven't seen this muni bond hysteria yet. I mean, that everybody has been calling.
We've seen things happening on the yield curve, I take it.
Well, can I point out a couple of things? One is when you mentioned muni bonds, the key word being muni, okay? Municipalities have a bankruptcy option. This conversation almost invariably devolves back into discussions of things that are municipal problems. We're talking about states. A lot of this discussion, I think, proceeds from the just sort of like relentless urge those of us have who look at these things to say, I've got to break into this democratic mess and straighten it out. Okay? And you asked a great question because you said, well, what will you do about it? Okay? About what? Illinois? It's not, I'm not going to do anything about Illinois. Okay? There's some interesting poetic justice here. In two places, California is in a mess that is the product of policies set in motion over the long term that were either initiated under or supported by one Jerry Brown. He's governor again. He's got to clean it up. The Speaker of the House of Illinois is a uniquely powerful guy who's also the chairman of the Democratic Party of Illinois. He's been the Speaker for, I guess, 30 years. He's been around forever. The problems that Illinois has are largely the result of policies that were initiated, put in motion, or extended under him. He now has to be responsible for cleaning up. He was elected, unlike any of us.
Absolutely.
And Ed Koch, who in case you don't know is a former mayor of New York, once said, it probably, I'm not sure, was in the wake of his election defeat in 1989, the people have spoken. Now they must be punished. Okay? The people in these states have spoken. The people of Wisconsin and Ohio spoke in one way. The people of New Jersey have spoken out of both sides of their mouth, or their heads, both halves of their brain. They elected Chris Christie governor, and they have a Democratic legislature, and they have a tug of war over some issues that are far from resolved. The people of California spoke, who bucked a national trend from the top of the ballot on down, and spoke in yet another way. They now have a problem that they have to straighten out, that the government there has the power to straighten out. And this gets to a question, I'd be interested in hearing Clay's discussion of this because we were discussing it beforehand. There's two types of contagion here, and I think it's a legitimate point. There's the contagion we've been talking about is the contagion that would accrue to other municipal bonds and state bonds from a bankruptcy, just the existence of a bankruptcy statute. The counterfactual or the alternative is what type of contagion exists if Illinois just resolutely, which is probably the worst player out there in some ways in the way we're discussing, just resolutely just fails to step up to the plate and do what it needs to do and like arrives at a point because of a set of external circumstances that are all in the wrong direction where it's just out of money or it has to go pay-go on its pensions. What is the contagion of that problem left that way to the rest of us?
But if you don't mind just letting me respond for one moment. I am a very happy member of the Fourth Estate and very happy that I am a not elected official. But I think we can. But listen, I think we all can agree, though, to Clay's point, even that we're not talking about this ex post. I think that that's a lot of progress. This guy came up with an idea. We're all debating it. All hands on deck here. President Obama has a website or a box or on some, I don't even know what it is. It's like an idea box online or something. All ideas are welcome because we are talking about this before it's a Lapin, before it's a disaster. I'm sorry, I just wanted to throw that out there.
I think EJ's just right in his democratic theory about if you make a mess, you ought to clean it up. And that's what I love about federalism. Federalism is great in that it allows sorting and it creates interjurisdictional competition, and we all think that does wonderful things like allowing people to satisfy preferences in jurisdictions that cater to those preferences and reduces corruption and creates all kinds of fiscal efficiencies through competitive mechanisms. As long as both the costs and the benefits are realized within that jurisdiction. The great problem occurs once a jurisdiction engages in activities that has spillover effects that interfere with my sovereignty, when your sovereignty, the exercise of your sovereignty impedes the exercise of mine. And I think that's what you're getting at. So if Illinois simply says, forget it, never mind, we're just going to go on our way, we're going to take David's default option. We like what he said, we'll just pick and choose who we pay, and it might not be everybody, but it will be the people we care about politically. Under those circumstances, I think you get two effects. First, you get some moral hazard. Other jurisdictions say, hey, if that's working out for Illinois, maybe we ought to try that. Why don't we free ride on the efforts of others as well? And even those jurisdictions that say, bad Illinois, you're a bad actor, they also suffer because the creditors can't distinguish between those who are going to follow Illinois and those who can't. So my response to David's federalism is, wait a minute, this isn't a situation in which all our principles of federalism ought to dominate, because there's huge spillover effects if a state has created problems for itself and there is in fact contagion. So we're down to an empirical issue, I think, which I can't answer other than pointing to a few studies that David doesn't like much. What will the degree of contagion be? I'm not sure. So maybe it comes down to how risk averse are we to the existence of contagion.
So one of the reasons I asked David earlier why he thinks states got into bankruptcy is that I think that the political accountability of state legislatures has declined substantially, and that that's behind a lot of our budget problems. That one of the things we've seen in the last 25 years is an enormous increase in the correlation between congressional voting and state legislative voting. That in fact, that split ticket voting is a thing of the past. People don't pay attention to state legislatures when they vote at all. The governors there's some split ticket voting, but there's none on the state legislative side, virtually none at this point. What this means is that state legislatures have very little incentive to cater to the median voter, care about debt problems, because their interests in staying in office are almost entirely determined by their primary electorates or other entities. That one of the problems with asking states to bear their own risk is that I don't think they will. I think that in some situations they will. I think that when you said Illinois will have their unintended consequences to its tax increase, I think those are intended consequences. Those are just consequences. They're not unintended consequences.
Okay, great. It's Q&A time, but I see my name on this paper, and I really want to know what he wants to say. So really quickly.
Since I'm criticizing here, I had the other Nicole in mind, although when I wanted to, I love almost everything this Nicole says. So listen carefully when she opens her mouth. You don't have to listen quite as closely as we go down the line. What I wanted to say is on this point that we don't care what states are doing. They got themselves into it. They can get themselves out of it. We seem to be a little bit selective about when we apply that principle. Everybody seems to have ideas about how we should be helping the state. And so I was just thinking, Nicole has a wonderful idea about how Congress should provide stimulus money to the states in response to states agreeing to decrease spending down the road, to sort of get their fiscal house in order down the road.
Because the stimulus is drying up now.
Absolutely. EJ has some great ideas about how we should change Medicaid. We should turn it into a block grant kind of approach. I like both of these ideas. 2 points about them. One is they're not at all inconsistent with having bankruptcy in there as a last resort option. And the other is they're examples of Congress trying to do something to help the states, which I think we all at the end of the day end up doing.
Q&A time. Tony?
Thanks all of you for this. It was really, really terrific. Just one quick comment and then a question. And a comment is on just talking about how difficult it is to actually make this political decision to go to bankruptcy, right? I mean, talk about what a governor will do or say, and what you're really talking about is a former governor, right? And that's what these things are, right? You're not talking about it, then we talked about, mentioned Argentina, right? Argentina went through 5 presidents in 2 weeks, right, to get through their default. So it's really hard. States are going to do everything they possibly can to avoid it. California will sell naming rights to the Golden Gate Bridge before they actually get to default. But something came out of the wake of Argentina and the messy way that was dealt with creditors and bondholders, and it's outside of bankruptcy. There was a lot of talk. IMF had plans talking about plans for a bankruptcy court, and what came out of it actually was the introduction of collective action clauses in bonds, right, which Mexico and Brazil and a couple other countries came forward with and started including. And there was a lot of concern at the beginning. They courageously stepped out and put collective action clauses in.
With a big push from the U.S. Treasury.
There's no question. Yeah, we pushed, but they were they were still the ones who had to go out there in the markets and put the clauses in. And this dealt with how things would be resolved in a default. And the concerns were that it would raise borrowing costs for the countries, which we didn't see, and the concerns were that that it would encourage bankruptcies in the future, which to date we haven't seen yet either. So my question is, for a state sovereign, is that a solution that they should be considering?
By the way, all the governors that I've spoken to hate the Argentina comparison.
You don't really want to identify yourself with the most profligate country in the world. I actually think that's an interesting idea. I would be completely sympathetic to it. I do think the way the bond markets responded is evidence that restructuring isn't going to destroy the markets the way people fear. I don't think it's a complete solution for states, because as compared to countries, Bond debt tends to be a relatively small portion of their debt. Pensions, collective bargaining agreements, Medicaid obligations, those are a much bigger chunk. But I definitely think collective action problems would be a good step.
You guys agree with him? I'm sorry. This is a watershed moment.
We asked the question.
Okay. Yes.
This is a question directed towards EJ, and I guess it's more in the way of an observation to see if I understand your position correctly. The conversation seems to have evolved that there's in effect a competitive contagion effects. The idea of a state bankruptcy option may have this contagion effect, but then ultimately right here at the end, there seems to be an open acknowledgement that states could just default. There seems to be the acknowledgement that that could just happen. And if I understand your position, Mr. McMahon, that your concern for federalism would be such that that would be okay, even if there's no federal bailout, whether the Congress or the Fed, and that the states are just going to have to make do with the cost of that, even if a state bankruptcy option ultimately may be less expensive from the viewpoint of the market because you have a orderly, predictable, proven technique for handling these kinds of claims under federal bankruptcy law. So I'm wondering if that is a correct assessment of your position.
Well, to get it to the end of your question first, I think it would be disorderly, unpredictable, and unproven, and ultimately not credible as something as the lever that we would hope for. And I think we all agree at core the need for something. The question is this a fix? And the core of my argument is this is not a fix. And so the core of my position is don't kid yourself. And therefore, if the fix is let's find a way that will make it a lot easier for states to surrender their sovereignty at the door if they somehow decided that was worth doing, and that will be the fix, that there will be no quest for bailouts, and that they will then have more ability, just the existence of it will allow them to address their problems more forcefully, and they will be less likely to demand bailouts. In any financial disintegration I can envision that begins to bring a state to the point of maybe choosing to default deliberately or to threaten somebody with bankruptcy, if you could structure the statute credibly enough to make that a credible threat. And this was, I took to be the core, really, of the initial, of Professor Skeel's initial article in the Weekly Standard. I'm calling you that not out of unfriendliness because there's at least one other David on the panel.
Oh, I was wondering.
I didn't want to confuse it.
I was sort of pleased that my statue.
I didn't want people to say. I didn't want to say don't listen to this David, but that David, because I don't know.
It made me think of when they were doing bankruptcy reform, and a senator waved up something that had 20 professors' signatures on it as evidence that it must be outrageous.
Right.
If professors are saying this, it must be outrageous.
I didn't say the professor because I'm seated between two of them. But it's not going to forestall. It would not forestall bankruptcies, and it wouldn't give them tools they don't already have. That's my argument, and so that's why. And the price to be paid for that is to give them another way, even in theory, to sort of check their sovereignty at the door, to be less sovereign, and to believe that somehow there is a sort of apolitical or less political way to force really significant structural change in an intensely politicized climate. And I would just give one example. Clay talked about about whether you could have something like the state control mechanisms. In fact, in New York right now, there's a pretty clear, good statute. It is proven and predictable, or at least people thought it was for 30 years, under which a control board just took control of the finances of Nassau County, one of the largest counties in the state and in the country.
And richest.
And one of the richest. And the Republican county executive is furiously challenging it as political, motivated by Democrats with partisan interests, and he's challenging the whole statute in court. All over differences of what kind of, among other things, what kind of accounting you use to deduce whether a unacceptably large budget deficit at the end of this year is imminent or not. There's just no way, I think, to have some sort of credible turnkey mechanism to drive this, is what I'm getting at. And again, I see unintended consequences galore and don't really see the benefits that are promised. That's my simple position.
Yes. Lady in red.
Thank you. I'm going to go back to the international for another question that has nothing to do with Argentina. It strikes me we've got a big example of this debate in Europe right now. And I'm wondering whether the panel views what Europe is doing as either an object lesson, which makes the case for a desperate need for a bankruptcy system, or an example of the futility of a bankruptcy system and the predominance of politics over a bailout mechanism and who gets paid. And I'm thinking there in particular the shifting terms with respect to Greece's bailout package.
So is our obsession with the Eurozone debt crisis a reflection of our own nervousness about our own fiscal house as well? And what can we learn from them? Granted, the size of Greece is negligible compared to California.
But there are some interesting analogies. For instance, now that we have a unified euro, at least for now, you don't have the option of simply inflating your currency. And that's very similar to a state. A state can't inflate its currency to get out of the problem. So from that perspective, the Eurozone and the issue of states' fiscal mess are a very interesting analogy, I think. The way I read what's going on in Europe is I think the moral is you can't credibly pretend that you're not going to do bailouts. I mean, what I see them as doing is they're not putting in place a real restructuring mechanism. They're trying to pretend that we'll do a bailout now, but we won't do it in 5 years. And I just think it's not a credible promise.
I think it's an object lesson of something. I'm not sure whether it's an object lesson of bankruptcy. It ties into a very interesting literature that's developed over about the past 10 years in political economy that is very empirically based and suggests that subnational debt can have, or subnational fiscal policies can have very significant implications for national fiscal stability. Now that essentially, if you treat the Eurozone as a nation and all these countries as subnational, that's exactly what we're seeing. We're seeing sort of mismatches between, and we see in the United States to the following extent. We see mismatches between the capacity of state governments to decide how much and how risky to incur debts and other obligations, whether it be GO debt or pension obligations, and the capacity of the federal government to control that level of debt, which under our constitutional structure is essentially zero. That is, the federal government doesn't control the subnational incurrence of debt at all. So what we're learning from the pigs, Portugal, the I is either Italy or Ireland or both, depending on your ethnic preferences, Greece and Spain, what we're learning is just a manifestation of the capacity of subnational units to adversely affect national fiscal stability. Now, maybe that calls for something like a bankruptcy procedure. Maybe it calls for some sort of mechanism by which there is a greater match between the capacity of that unit of government, the central government that feels the negative implications of over-indebtedness, and the ability of those subnational units to create over-indebtedness.
It also shows how the bailees have tremendous leverage over the bailers. Why is Germany bailing out Ireland? Partly to protect the continental European banks. So Ireland can go and likely renegotiate this bailout and get better terms. A country like Greece, they have leverage that they could pull out of the euro if they don't like the terms of the bailout. And that's true now. That's true 6 months from now if they change their mind about what they've agreed to. Same thing in the States. A state could say, we're simply not going to provide medical care for the indigent. We can't afford to. It's unlikely that the U.S. government would allow that in a very populous state. They even have leverage through the financial markets, where if they don't pay their bond obligations, value of those securities goes down. You may not have 2008-style crisis, but you have banks who have to pull back lending, possibly harming their recovery. And so they certainly have a great voice at the table here because of that.
Craig?
I'd just like to ask a question to Mr. McMahon. As you alluded to the mid-70s in New York City, where we had the Financial Emergency Control Board, you mentioned sort of in passing that the union stepped up as the bonds were coming due. And since you referred to making sausage, it seems the unions were willing to eat their own sausage for quite some time. And I believe it was up to almost $4 billion out of the $8 billion in pension fund assets through 1978 that the unions were actually buying. And now you had Municipal Acceptance Corporation, you had the Emergency Control Board, but I think when the unions started buying, not just for the weekend, but starting to invest, that's the notion of nothing focuses the mind like a hanging.
Thank you very much. That quote was very much what characterized what happened then. There's a crucial distinction I would keep in mind. This wasn't like the Teamsters Benefit Fund. This wasn't the union's pension fund. It was the city pension fund. It was the city's pension fund that had to pay the union benefits, and it was the union's trustees on the pension funds. Their votes were required to do that. There's a crucial distinction that also gets into the issue here. Pension funds in general, I would observe public pension funds predate collective bargaining. There's lots of people in public pension funds who are not union members. I'm an inactive member of the New York State and local retirement system, barely vested in a pension that, while tiny by public sector standards, would cost me a couple $100,000 in net present value to replicate. No union's ever represented me. Can they throw in the towel for me on some sort of future negotiation? Not that they would. Is that one of the legends of the fiscal crisis is that the unions did something with their pension funds. These are members of unions who, under the New York State Constitution, were guaranteed their benefit, and whose unions have members who were trustees of the funds who agreed not to stand in the way of the funds buying the bonds. By the way, the State Court of Appeals wouldn't let the state pension fund do the same thing when it objected to it, because that had a sole trustee. So it's the New York City fiscal crisis is a really interesting lesson, because in many ways it fit the pattern that Professor Skeel, David, has outlined, which is the existence of a bankruptcy threat had a very real effect on that process. There was a vice. One part of the vice was Chapter 9. The other part was Congress holding out on them. The headline, Ford the City Dropped Dead, that precipitated the haircuts for the bondholders and some final union concessions. And then things proceeded from there. But you know what? At the end of the day, they took a 2 or 3 year wage increase deferral, which meant more then than it would now because inflation was higher then. New York City and Cleveland both got out of their crises then, largely because in the end, in the city's case, the stock market's rebirth in the early 80s and inflation. It was like Argentina, except the whole country was doing it for them. The larger economy went through a surge of inflation that deflated the city's obligations.
And let's not forget that the New York City bailout was at some levels unconstitutional under the state constitution, under Flushing National Bank, and probably violated, terms of it, probably violated the full faith and credit clause. And it didn't actually end up mattering that much in the end because of the timing that it took for the decision to be enforced, and because of the recovery. But it was pretty clearly unconstitutional under certain parts of it, the forced rollover of debt. And so I think that it's one of the situations where we've got a story of something that worked, and the ways in which it didn't work are almost exactly the ways in which the bankruptcy proposal mirrors it, and the ways in which it did work are the ways in which it is opposite from the bankruptcy proposal.
You actually, though, make an interesting point when you say things like the rollover was unconstitutional. If they had filed for bankruptcy, effectively it would have been a rollover.
Yeah.
I mean, that's what, one of the things.
Automatic stay.
That's right.
Yes.
So that there may be a place for a type of bankruptcy to deal with these kinds of issues, because you don't want these emergency measures to be treated as if they're unconstitutional.
Just a footnote. I think that's a great point. And a footnote on that, historically, what the states have done in a crisis is effectively do a temporary moratorium on debt. And in the 19th century, this repeatedly proved effective. And so that limited effect of a bankruptcy, just a temporary stay, could be a lot. It could be all that, in some circumstances, is needed.
I am getting the wraps. I think I've been a terrible moderator because I just want to hear you guys talk all day long, and there's so much fire in my belly. I guess we're out of time, unfortunately, but I just want to thank this amazing panel. We went from Anna Karenina over to Argentina and back again in what it was a really inspiring discussion, and you all will forget much more than I will ever know about the subject. So I'm humbled and honored to be here, and thank you all for your questions and your time. Thank you.
I think it is clear how fortunate we are to believe in the power of ideas.
Supply the common sense and the fresh thinking of the Manhattan Institute.